to hire a lawyer can feel overwhelming, and it's an important decision if you're in need of legal representation. It helps to know how lawyers get compensated. And here to break all that down, Tom Sinas, Sinas James Law Firm. Good morning, Tom.
Good morning, Todd. Thanks for having me.
Absolutely. Now, we see commercials all the time. No fee unless you win, right? That seems to be what we're talking about today. Is that a contingency fee attorney?
It is. And as you alluded to, there are lots of different reasons that people may need lawyers, and then lots of different ways that lawyers may be paid, or at least a few different ways. But the one that you're referring to is what we do call it contingent fee representation, or a contingency fee. And let me just first make a point of why I think it's really important. Most of the people that I represent, and I think most of the people out there, don't have a stockpile of cash that they set aside to pay a lawyer to work by the hour, particularly on something that they never thought that they would need the lawyer for. And so when the need arises, they're faced not only with the legal challenge, but they're also faced with the question, well, how am I going to pay the lawyer? And the essence of a contingency fee is the idea that the lawyer is not compensated for his or her time unless there is a successful outcome in the case. So like you said, some people say no win, no fee. It's a shorthand way of saying the same thing. The lawyer is not compensated for any of their time unless there is that successful outcome. That's the contingency being the successful outcome. And then it raises the question of, well, how much is the lawyer paid? And we can talk about that in a minute. But the concept here is that contingent event being the successful outcome. But more importantly, I think the bigger concept here is that were it not for this, so many people would not have access to a lawyer because they would be left with the more common alternative, which would be to be forced to pay the lawyer by the hour.
You know, you brought it up, and it was my next question. They never really say what that fee is if you win. So how much of that are they taking if the successful outcome is achieved?
Well, we have some general rules that we get from our court rules and from our rules of ethics in Michigan. And each state differs in this regard, and that is important. The most common cases where you're seeing contingent fee representation are cases involving personal injury, wrongful death, or auto no-fault benefits. And in that case, we have a specific rule that says that the lawyer cannot charge a contingency fee that exceeds a third of the net recovery. Well, what is the net recovery? Well, the net recovery is the idea that when a lawyer prosecutes a case, there's of course going to be the lawyer's time, but there may be other things that the lawyer has to invest in, other outside costs. They could be filing fees, expert witness fees, and the like. Those are costs. They're not lawyer time. Those costs are subtracted from whatever the recovery is. And then what is left under a contingency fee is divided between the lawyer and the client. So if it's a third, as the court rule authorizes, then a third of what is left goes to the lawyer and 2/3 of what is left goes to the client. Again, in these common cases of personal injury, wrongful death, and no fault benefits. So most people, I think, will encounter lawyers in this particular area working on a 1/3 contingency fee. There are other states that allow lawyers to charge more than that, 40%, maybe in 50%. But in those personal injury, wrongful death, and no fault cases, that's not permitted in Michigan. And I think that's really important to know because I have seen clients of mine encounter lawyers from other states who are trying to work on cases in Michigan, and I have seen those other lawyers from out of states not be aware of that 1/3 limitation.
Is it important for someone who's needing legal representation, now that they have this information, to know what those costs are up front? I mean, that may be a difficult question to answer, but you mentioned there's a settlement. Yeah, you've won the case. The costs, those fees for filing and experts and other things that you mentioned, are subtracted from that total, and then that net gain is split into, well, typically 1/3, 2/3 for a payout. So a lot of people watching this may be wondering, well, how do I know what the fees are going to be? Or how do I know what those costs are going to be?
It's a great question. And there really isn't a specific answer because you don't know how much investment is going to be needed in your case. You don't want to work on your case on the cheap and not invest on the things that are important. Generally speaking, I tell my clients that costs are a function of time. The more time your case takes, the more costs will be incurred because the more things that need to be done. So it's really impossible at the beginning to predict the amount of costs. But one thing that is really important is that a client, let's say a client of mine, can call the law firm any day and ask, how much have we spent in costs? And they can be told that on any given day. So you don't necessarily know beforehand, but you can know as you go, and you can understand the general concept that the more involved the case gets, the more the costs rack up over time. But what's important here is that these costs come off the top of the settlement. And that's important because the lawyer and the client are sharing in the costs. That 1/3 fee is not computed until the costs are subtracted. So that means that the lawyer, as they should be anyways, should be investing in those things that the case needs, and the lawyer is sharing in the cost and the risk associated with those costs.
It's all vital information. Are there any other rules that apply to this that we should know about?
There are a couple quick ones. One, contingency fees need to be in writing. That's clear under law. Number two, a lawyer needs to tell a client that the client could hire a lawyer on an hourly basis. They don't have to hire the lawyer on a contingency fee basis. It's up to the lawyer to decide whether he or she will work on an hourly basis, but the option needs to be extended. And number three, there are certain areas of law where contingency fees are not allowed. Domestic relations and criminal cases, most commonly. The rules of ethics do not permit lawyers to be retained on a contingency fee basis there. So, and there are some more technical ones, but those are really the high points. And I encourage people, if they have questions about this, if they're interviewing a lawyer or talking to a lawyer, ask a lot of questions about this. The lawyer that you're thinking about interviewing or hiring should be able to answer all of these questions.
And if you are looking to interview or hire a lawyer, of course, Sinas Law Firm, accepting people. How do we get a hold of you?
They can find us online at www.sinusdramus.com. Shoot us an email at info@sinusdramus.com, or give us a call 616-301-3333.